My name's Steve Bernard. To my right is the Honorable Bob Hawthorne. To my left is the Honorable Ted Tao. And we're going to be the division that hears the two oral arguments this afternoon. The first one of these is State versus the Castle Law Group, and I'm assuming that that's who counsel are at counsel table. The second one is Atrium Condominium versus NHK Investments. Are both counsel for that case here? All right, you're both here, okay. The comments I'm going to make are going to be to both cases, to the counsel in both cases. First of all, have all of you been able to familiarize yourselves with the instructions for oral argument?
Yes, Your Honor.
Yes, Your Honor.
Ma'am?
Yes, Your Honor.
Yes, Your Honor.
No, ma'am, you?
Yes.
And
Yes, Your Honor.
wonderful, thank you. And the second thing is, do any of you have any questions about those instructions?
No, Your Honor.
No, thank you, Your Honor.
No, Your Honor.
Okay, great, thank you. The second thing is, for the benefit of folks in the audience, we record these arguments, and they are live streamed. And so, as a result of that, counsel, please don't say anything that's confidential or that you don't want out in the public realm. This is a public courtroom, but more than that, it will immediately go out to the world at large. And we also archive our arguments, these video arguments, and so they're available to the public later if they wish to see them, as well as to counsel, the parties, and us. Next, because we have a lot of people in the courtroom I don't believe are here a lot, if anyone has a phone or a pager or other electronic device, please turn it off, not merely to silent, but to off. And the reason that we ask you to do this, please, is that there is something about the electronic field that phones generate that sometimes interferes with our recording system, and therefore we don't want to do that. And last of all, I see that there are some folks standing. I apologize for that. I don't want you to be uncomfortable, but it looks like all the seats are taken. But you're certainly free to remain. I'm just sorry that you're going to have to stand for the argument. That being said, each one of these cases is set for 15 minutes aside for oral argument, and we're ready for oral argument in State versus Castle Law Group.
Good afternoon, and may it please the court. Alyssa Garden-Schwartz, 36126, on behalf of the state. The district court said in this case, and I quote, "I don't get it. With apologies to the Supreme Court, I don't get it." The district court's order demonstrates that there are three things that it did not get that require this court to reverse the district court's judgment. First, the district court didn't get that foreclosure statutes, as well as mortgage servicer agreements that had provisions requiring the reimbursement of only actual and reasonable costs incurred in a foreclosure, operated as a check on free market principles and protected the consumers that were ultimately bearing those costs. Second, it did not get, and frankly, it simply disregarded the Supreme Court's Rule 21 decision, the law of this case, which held that disclosure does not immunize deception from claims of deception from a price. Finally, because it did not get and disregarded the Rule 21 decision in this case, it didn't get that its key factual finding that costs from the posting vendors and title vendors that the Castle law firm used contained benefits going back to the Castle Law Firm and its companies meant that every time the Castle Law Firm presented an invoice representing that the posting costs and the title search costs were actual to the Castle Law Firm, it was making a misleading statement of price. For these reasons, we would respectfully request that this court reverse the trial court's order and enter judgment on behalf of the state for both its CCPA and Fair Debt Collection Practices Act claims, and remand back to the trial court for the limited purpose of calculating appropriate disgorgement and penalties. In the alternative, we would request that the court remand the case back to the trial court for a new trial to address both its errors in disregarding the Rule 21, as well as its errors related to the law as it applies to invocation of the Fifth Amendment privilege in civil cases. I'll now go into the grounds that I've laid out for reversal in greater detail, and of course, am happy to answer any questions the court may have.
May I ask one, please, Ms. Garden-Schwartz?
Yes, of course, Your Honor.
Thank you. One of the things that concerns me about your argument, and I want some help with, please, is that the trial court found that there was no conspiracy. And at one point during trial, and I forget who it was for the state, but someone said basically, we don't really care if the price is high or not. What really matters in this case is the conspiracy. Because the trial court found that there was no conspiracy, where does that leave your argument about where the price is?
Sure, Your Honor. So I believe what the trial court found was that there was no conspiracy in setting the prices.
Right.
And that doesn't go directly to what our claims here. It wasn't just that we alleged that there was that the defendants, the law firm, and the vendors worked together to set the price. We also alleged that the law firms and the vendors worked together to misrepresent the price on the invoice as it went to the servicers as an actual and reasonable cost. So the collusion goes beyond just price setting. It's actually in presenting the invoice and representing those costs as coming from an independent third party where no money was going back to the law firm, when in fact, by the time that these invoices were going to clients, there was money coming back to the Castle defendants. They were misrepresenting with respect to the posting that the charges were coming from an independent third party, when in fact that was not the case.
Thank you.
Certainly. I'll start by going into the first grounds for reversal, which is the disregard of statutory and servicer agreement standards. So deeds of trust provided that lenders could recover for actual and reasonable costs and fees that they incurred in exercising their right to foreclose on a borrower. Colorado foreclosure statutes, as well as agreements with servicers, reinforced that by servicers telling their law firms that they could only submit for reimbursement of actual, reasonable, and necessary costs. And Fannie Mae in particular emphasized the reason for this requirement in telling its law firms that every dollar of increased costs amounted to credit losses to Fannie Mae. And because Fannie Mae's credit losses are taxpayer funded, every effort needed to be made to keep those costs low. That's what Fannie Mae told to its lawyers, to its fiduciaries. The trial court, in looking at this case, set aside that statutory intent, that market participant intent, that costs be kept in check, that free market principles, unbridled free market principles, had no place in this particular market. So when the court found that the posting costs and the title costs represented reasonable prices because they were, quote, what the market would bear, that finding had no place in this particular market, where the people ultimately bearing the costs were foreclosed borrowers in large part who had absolutely no say in how those costs were incurred and how much they were for.
Counsel, if it's not what the market would bear, how would one define a reasonable cost?
The way that we asked the court to look at a reasonable cost in this case was to look at what vendors who were not providing money back to their law firm clients, look at what those vendors charged and compare those prices with the prices that were charged by vendors who were in fact affiliated with their law firm and sending money back to their law firm. That was the way that we presented to the court that prices should be looked at as reasonable.
But didn't the court find that those vendors were not comparable and they weren't providing comparable quality services as the services used by the law firm in this case?
The court found that those vendors did not compare in terms of volume to the absolute firm in terms of the posting. But it found that they didn't compare to RERR. But it didn't discount the fact that those firms actually charged prices that were not the same prices that were charged as the absolute and RERR vendors, and that those prices didn't match. Additionally, it didn't see the real sort of question that we were posing, which is, again, if there's money going back to the law firm, how can these costs be actual to the law firm? In that sense, the comparison to the unaffiliated vendors here isn't necessary to ultimately find that there's been a Consumer Protection Act violation here. In going back to the court's disregard for the market participant and foreclosure statutes requirements in this case, the court should understand that defendants did not, as the court reasoned, lawfully take advantage of, quote, extraordinary entrepreneurial opportunities presented by the economic crisis. Instead, they simply took advantage of consumers. I want to talk about the court's disregard for the Rule 21. The court started out this trial by telling the state that it did not understand how, if a vendor charged a price and that price was passed along through the law firm to the servicer and paid by the servicer, it could not understand how that price was not actual and how that price could be deceptive. We know that the trial court didn't get away from that reasoning because in its order, it stated that the state had not demonstrated that these costs were actual because the price that the vendor charged matched the price that the law firm passed along to the servicers and what the servicers ultimately paid back to the law firm that went back to the vendors. At the same time that it made this finding, it distinguished that from what it understood to be going on with the Aronowitz firm, which was that the Aronowitz firm was taking a vendor invoice and incorporating, before it passed it along to the servicer, incorporating some sort of benefit to the law firm and then passing it along to the servicer, distinguishing that as violating the CCPA. In making that distinction, it clearly still did not understand the gravamen of our case, which was that the law firm and the vendor were working together at the vendor invoice level to make sure that benefits going back to the law firm were already baked into that invoice. And in making that distinction, it fundamentally disregarded and chose not to follow the Supreme Court's holding in the Rule 21, which is that the CCPA requires nothing short of eliminating deception entirely. That is, disclosure of a deceptively set price doesn't immunize that price from claims of deception. And as the Supreme Court stated in the Rule 21, in May department stores, in Dunbar v. Gym of America, the CCPA has a broad remedial purpose. And that remedial purpose is to deter and punish deceptive trade practices that have a tendency or capacity to deceive. Finding that a price, as long as it's accurately disclosed, can't be deceptive, cannot be squared with the CCPA's requirement that it be construed broadly and be acknowledged for its remedial purpose. So I want to turn to how it is that the court, because it chose not to follow the Rule 21, didn't understand that its ultimate factual findings that money was in fact going back to the Castle law firm through its companies from both the posting and the title vendors should have led it to find, as a matter of law, in our favor. It found, with respect to posting, that 40% of the posting vendors' profits was going back to a Castle business. And it found that Castle affirmatively concealed that affiliation from Fannie Mae. It also found that money was going back from its posting vendor, RERR, to the Castle law firm in the form of referral fees and tracking fees that it found to be somewhat troubling. Once it made those findings, it had ultimately found that when the Castle law firm presented an invoice to its servicer clients representing those costs as actual to the Castle law firm, that was a misrepresentation. Instead of doing that, the court looked at whether or not those costs were or the money going back to the Castle firm was for fair value. It looked at whether the consumer willingly paid the prices. It sought to excuse deception rather than to find whether or not it was eliminated. And that is not permissible under the CCPA. I would like to reserve my remaining time for rebuttal.
Of course.
Thank you.
Good afternoon. Larry Posner. My registration number is 2792. I appear in behalf of the attorneys Karen Castle and Larry Castle and their law firm, which we refer to either as Castle or Castle Law Group or CLG. My co-counsel, who represent Absolute and RERR, have been kind enough to grant me 11 of our 15 minutes, and I will try very hard to sit down so that they can speak.
I think that will probably be more important for them than for us.
They begin with the court didn't get it. The court disregarded. The court did not understand. These are lay people's words for we lost the trial and we deserve to win. But the reason we are here, the posture we are here on, is did the court follow the mandate? And the court unquestionably did. Now, the mandate from the Supreme Court had two parts to it. Evidence of market rate by unaffiliated vendors is relevant, and the court should consider it. The second one is that disclosure of a price charged does not automatically insulate a party from a claim that it's deceptive. Now let's go back to the first one. They went to the Supreme Court saying the trial judge will not hear our market rate evidence. The problem was not that the court wouldn't hear the evidence. The problem was with the evidence that they gave the court. Now, in a case that has gone to our Supreme Court on market rate, the trial court found this on the first day. The state never hired a market rate expert. The state conducted no market rate analysis. Next, the court found that the state, this very Attorney General Consumer Fraud Division, has entered into 5 consent decrees with the largest banks in America that says, in measuring the market rate of a vendor's service, here are the steps you shall follow. And the court found out that the state followed 0 of the 5 steps. Then they put on what they said would be the market rate, a handful of people they picked, and the court correctly labeled them cherry-picked vendors, and the court meticulously listened to every word of it and analyzed it and said, these are not of the quality, They cannot possibly give the quantity. They will not absorb the unlimited liability. And why is that important? Because the servicers impose on the law firms unlimited liability for vendor mistakes. And so Castle said to its vendors, if we have unlimited liability, you have it. And the court found fact after fact that differentiated these people. And then they had a backup argument. And the backup argument was, the court should find as a matter of law that the price for thousands upon thousands of required postings in a short time period all over the state, deferment postings and Rule 120 postings, should be no higher than the rare eviction posting. And the court heard that theory, and the court rejected it and said, wait a minute, a vendor who has to do a now and then is in a completely different quality and quantity than a vendor who must do 500 postings for Castle in 1 week, and a class action is waiting if they screw it up. To say that the court did not follow it is to ignore page after page of factual findings. There was no piece of evidence they submitted to the court on their market rate theory that the court did not listen to and analyze. Their real gripe is that the court disagreed with their theory. And the Supreme Court mandate was, you got to hear it, but the Supreme Court mandate wasn't the state gets to win. Now, the second part of the mandate was a deceptive trade practice that involves a deceptive price is not automatically shielded by a disclosure of a price. It's a two-part analysis, and we see that in May most clearly. You had a deceptive price, you later told the market, here's the real price. Do you get away with it because the real price was disclosed? The problem for the state is the court found there was no deceptive price. The court went to step one and says there is no deceptive price. The price disclosed is the price that was appropriate. And when we look at the court's finding, the court found the evidence is insufficient to prove a market anything less than $125. Next, no evidence produced by the state that $125 was substantially higher than market. They had this conspiracy theory, and the court, they pled it over and over. It's that people conspired to set the 125. The court made finding after finding on the evidence that said, no, I find that Ms. Benton set the price. I find that she set it all alone. I find that she did a reasonable market analysis before setting it. I find that she charged 125 for other law firms. I find that other law firms paid the 125. And the court found, as a matter of both common sense and law, that the price of a now and then eviction posting, where the liability for doing it wrong is minimal, is not the comparable price for a Rule 120 or deferment posting when the volumes are gigantic and the penalties for screwing it up are so much different. The court assiduously followed the mandate. Now, they also raise a Fifth Amendment issue. It's in their brief. They don't argue it on appeal, but a trial court is allowed to act on what the court knows. And what happened in this case is that the state told the judge that the Aronowitz firm took vendor postings from their own family company that were $50 or $75 and marked them up to $125 to $150. This was never an accusation against the Castles that there was ever a markup from the vendor. And as the court pointed out, when Ms. Aronowitz, through counsel, invoked the Fifth Amendment, the state said, well, you haven't heard the questions. The court said, ask the questions. Here's your time. And they made an offer of proof, and the court can look at them, and every one of them is going to cause a Fifth Amendment by any lawyer who's thinking. And what happens? When the court hears from both the plaintiff and the defendant that there is this evidence of independent fraud by another law firm, whether or not proven, The court rules Aronowitz arguably had more to worry about than an unproven price-fixing charge. There was evidence presented suggesting that the Aronowitz firm may have defrauded its clients submitting fraudulent bills, and the court found it was entirely reasonable for her to take the Fifth Amendment. And then the court said, I've heard that she's taking the Fifth. Now you're asking me to take the adverse inference. I declined to make the adverse inference, and that is reviewed on an abuse of discretion standard, as is the court's decision that a witness can take the Fifth Amendment. Then we have Ms. Chopin, and Ms. Chopin never took the stand, and they were the ones that told the court, Ms. Chopin's not going to testify to anything. They did not preserve it, and they invited the error. So, at the end of this part of the case, a case that was supposed to be about collusion, and the court having found no collusion, and a case that's supposed to be about market rates, and the court saying, you have not proven a deviation from market rates. If anything, the case proves that the reasonableness of the market rates, then the court went on. But before it did, it also took time to look at their title allegations. And the title allegations were similar, that RERR was in some way in the pocket of Castle, and that charging for title searches at $275 was not the reasonable price, the market price. The $275 was set by Fannie Mae on its own, escalating the previous price, because when it had told the law firms, we think you should hire people for $200, and Castle said, this is in evidence, you can't hire good people for $200. Do you have some people who'll do this? When Fannie gives them the names, 2 title vendors go bankrupt at $200. It's Fannie Mae who ups the price. And what does the court say about it? The court says that there is ample evidence that RERR gave better title searches, that there is a big difference in quality among title companies, that even the state's witnesses admit there's a difference. And the court finds, I've listened to the 2 people you cherry-picked, and I find qualitative and quantitative differences. In fact, one of them doesn't even know how the super lien of homeowners associations works in Colorado. These are fact-bound inquiries that they say to you, the judge didn't get it, the judge disregarded. Their brief is replete with disregarded, failed to consider, wrongly considered. These are all the words of a lawyer who got a trial and doesn't like the factual result of the trial. And now it's camouflaged under, let's see if he followed the mandate. Now, the second part, when they say, the price was deceptively set, the court found against them. The court found, no, there was no deception, there was no collusion, there was no conspiracy, there was no antitrust violation, that this price made sense. Then we move on to the cross-appeal issues, which are critical. Our argument is that of a CCPA violation in this case, in the way the court did it, is not sustained by the CCPA. Even the most laudable law has its limits. And the Supreme Court has said, what you start with, what's the title of it? The title of it is the Colorado Consumer Protection Act. Castle is a law firm under a retainer agreement with the most sophisticated clients you can imagine, and the court found that. And it negotiates with Associate General Counsel of Fannie Mae. And having done that, it lives up to it and provides the posting it is to provide to its clients. And if we look at Martinez, the Martinez case is instructive. Certainly, Ms. Martinez could under the wildest imagination, be considered a consumer. She is, after all, the person undergoing a physical exam, and the Supreme Court has no problem saying she's not protected by the CCPA. The issue before this court is not whether consumers will be cast adrift. The issue before the court is whether the CCPA extends to people outside of the contract who are investors in a sophisticated public company when Castle has two clients, both sophisticated, Fannie and Freddie, who have agreed to the number. And quite simply, these are not this notion of downstream or investors as consumers extends the CCPA to virtually every business relationship. And the court points out, by the way, you never, as a state, called any servicer, you never called any of the banks, you never produced any evidence that they thought they were taken advantage of. I've used up my time, but we also have a statute of limitations issue, and I asked the court to look at Carlson, Jenkins, McCoy. What we see is two statutes that are identical, fine. The specific trumps the general, but not necessarily when they have different penalties, when they cover different conduct, you can have a different statute for some parts and not the others. Thank you.
Thank you. Counsel, you have 1 minute and 39 seconds.
Thank you, Your Honor, and may it please the court, I'm Dan Vedra. I'm here on behalf of RE Records Research. And I would very briefly like to address the question that Judge Tao posed to the state, which, if I transcribed it correctly, was how does one define a reasonable cost? And I had the state's answer as, look at what the other vendors that are unaffiliated are charging. There's a sincere problem with defining it that way because there's no limiting principle as to which vendors can be chosen. The correct way to define a reasonable cost is what the state was attempting to put on as their evidence, which is to find what the market rate is. And in this case, the appropriate thing for the state to have done would have been to commission a market rate study to define the terms of the market, to define the cost, to define the different characteristics of the vendors providing the products that were used in the foreclosure, and determine how that was different than what the title search vendor and the posting vendors were charging. That would have a limiting principle to it. There's something that can be replicated with ease. Whereas if you're defining that based upon how one person chooses a different vendor, there's no limiting principle because there's no basis for determining which vendor you should be comparing it to. And what the court did was absolutely correct. It looked at the qualitative differences between the vendors and determined that a higher price is justified based upon a higher quality product, which is what Real Estate Records Research produced. One last point. At the beginning of the state's argument today, they stated that they would ask this court to enter judgment in their favor against the defendants. This is the first time that the state has asked for this relief. Looking at their briefs, they've all asked to have the case remanded for a new trial and at the same time have maintained that there is no dispute as to material evidentiary facts. For that reason, I would ask that the court affirm. Thank you.
Thank you, counsel. I'm sorry, counsel, but you're out of time. And bailiff, if you would put 10 additional seconds on the clock for Ms. Garden-Schwartz, please. Let's wait till we get that up.
Yes, Your Honor.
Okay, thank you, ma'am. Please proceed.
Thank you, Your Honor. I want to be clear about why we're appealing and what this case was about. This case was about whether or not the Castle defendants and their vendors misrepresented their costs as actual and reasonable when they submitted them for reimbursement. Under the law, those costs can't be actual and reasonable if they are deceptive. And it is our allegation that, again, because the Castle law firm, every time they submitted an invoice, submitted costs that came from affiliated vendors and vendors that were giving money back to the Castle law firm, they were misrepresenting those costs as actual to the firm. We are here because we have an issue with the law that the court applied, not with its factual findings. Our view is that the court took an erroneous lens and viewed all the facts through that erroneous legal lens. That erroneous legal lens was that deception can be excused, deception can be explained, and a consumer's acceptance of a deceptive price makes that price not deceptive by definition. That is not the law under the Colorado Consumer Protection Act. We are not here because of a contractual dispute between Fannie Mae and its law firm vendors, its fiduciaries. We are here because the impact of what happened here, this deceptive pricing, reverberated down to foreclosed borrowers, people trying to save their homes. That is why the Attorney General brought this case, and that is why this is not a pure contractual dispute.
Thank you, counsel. Thank you. Thanks for both sides. We appreciate your arguments. The case will stand submitted and an opinion will issue in due course. That concludes the argument on this case. If counsel on the second case would please come forward and take counsel table, we'd appreciate it very much. Are we ready? Let's proceed.
Good afternoon, Your Honors. May it please the court, my name is Nina Kazazian. My attorney registration number is 21910, and I'm here on behalf of the appellants in this case, NHK Investments LLC and myself. The issues on this appeal relate to whether the court had in front of it sufficient evidence or had evidence presented by the appellee that would allow it to find that there was a settlement agreement in this case. The court allowed appellee's counsel, who is also at counsel table, to present only an offer of proof. Appellee offered no evidence, no testimony, and in fact blocked the appellant's request to obtain the testimony of the Homeowners Association board members at the hearing. The court, it is our position that the standard of review, which requires which presents that the appellate court should defer to the rulings of the trial court if the evidence presented at trial allows one view or possibly two views. The situation here, Your Honors, is that the only evidence that was duly admitted in this hearing on May 25th, 2017 was the evidence presented by the defendant's appellants.
Pardon me for interrupting, Ms.
Yes,
Kazazian,
Your
if I
Honor.
may, please. I understand that part of the offer of proof included documents and emails. Is that correct?
That is, Your Honor.
And was there an objection to the foundation of those?
Yes, Your Honor.
And what did the court say to that?
The court overruled the objection and allowed those documents to come in, I believe on the basis that those documents had previously been filed in the case.
And if I may, and let's assume for the purposes of our discussion that the court properly admitted those documents. If that's so, then doesn't that establish the existence of the agreement?
No, Your Honor, it does not, for two reasons. The first is that, as I'm sure Your Honors know, the court, on the district court level, relied heavily on a particular email that was sent in the morning on May 4th. And the court determined that that was essentially an admission and an acknowledgement of the terms of an agreement that had been rescinded. That was in error because at the time, the defendant or the defendants did not have in front of them a draft that provided the information that the appellee provided 2 hours later, and that draft contained different terms than were discussed. One in particular was the fact that Ms. Weigler, counsel for the appellee, unbeknownst to the appellants, had slipped herself into the waiver. The waiver of rights and claims included a statement, comma, that all claims would be waived and released against the attorneys of the HOA. And we objected to that. That was never discussed, it was never agreed in the first instance, and it remained in the draft that was sent again at 10 o'clock in the morning on the 4th of May, 2017. There could be no meeting of the minds on the scope of that waiver. Those issues were discussed later in the day by email, and Ms. Weigler simply did not respond and went out of town. So essentially what the court did at the trial court level was take 8 hours worth of emails with no signed agreement and say, we have what normally would be considered negotiations. It's not uncommon for parties to send drafts containing what they want. But if this court were to decide that sending a draft that was never signed could constitute an enforceable settlement agreement, Your Honors, I submit to the court that that upends quite a bit of legal authority and heritage in this state.
In what way, counsel?
Because the basic contract principles require an agreement as to essential terms.
So if the email, unsigned, contains essential terms, would that not at least be an offer? Would it be a manifestation of an intent to enter into a bargain?
Your Honor, I'm not sure which email you're talking about, but if you're talking about the one that the court relied on at 8 o'clock in the morning, that...
Let me stop you there.
okay,
I'm talking in generic sense, because you said in a very generic way that if there's an unsigned email, it can never be a contract.
Oh, I did not mean to say that. What I meant to say is that a draft agreement that was never agreed to cannot be a contract.
But if you email a draft agreement,
Yes.
is that an objective manifestation of an intent to enter into a bargain? Or at least could it be?
It could be.
So if the other side accepts it, whether there's a signature or not, you've got a contract, right?
If the essential terms, essentially, yes, that is possible. However, that's not what happened in this case. What happened in this case is that there was a discussion by email of a particular part of the agreement, not the entire agreement, one of the terms of the agreement. And then the terms that were provided in the draft were not the same. The date of effectiveness, the appellee sought to have that retroactive. That was not discussed or agreed. That was not on the original agreement. And there was also a discussion about making sure that rather than having a two-step process, as was decided in mediation, that at this point, since there was no mediation agreement because by operation of law, an agreement that's rescinded no longer exists. You cannot reaffirm a rescinded agreement. You can put it.
Isn't that what you said you were going to do?
Well-
You were going, yeah, I think you said in the email that this is now okay with both parties, me and NHK, and so we'll reaffirm the rescission, the rescinded contract with the terms that you had asked to be included and that the association's council had agreed to.
That is what the language said, but doesn't make it a legally effective thing.
Why not?
Because-
Everybody knew the terms of the rescinded contract. They knew what they were dealing with
Well,
already.
in this case, Your Honor, I would respectfully submit that the terms of the draft that came across were not what was understood. The terms of the changes to paragraph 5 should have also been paralleled in paragraph 2, and in addition, and they were not, and in addition, as I said, the scope of release was never discussed, that claims against the individual attorney would also be waived, especially since there were claims that had been discussed after the fact. And the other issue here, Your Honors, is that we submit that in this particular instance, because what the HOA was trying to do was divest the owner of the property, NHK Investments LLC, make that owner sell the property, that the statute of frauds should have applied. One of the essential terms discussed and understood by the parties was that the agreement would be in writing signed, and the plaintiff HOA never did sign it. There never was any information or testimony at the hearing that any of the board members knew about or agreed to any of the changes. And the facts and circumstances surrounding the timing of the communications back and forth also indicated that there just simply wasn't any time for Ms. Weigler to actually talk to the board members.
Pardon me for interrupting, Ms. Kazazian.
Yes,
but
Your Honor.
I have a concern, and if I may, if you'd address it for me. You know, there is a standard in society and in the law too, that you should mean what you say and say what you mean. When you send that email to which Judge Hawthorne referred, basically saying we're on board, everybody is on board, I would think that at that point, Ms. Weigler is free to rely on that and say they're on board. And my worry is that the rule that you propose would be that, would undercut the Supreme Court's holding in Yeagle and would basically say, unless both parties simultaneously sign the document and then swear this is what we wanted to do, that you wouldn't have a contract. And I don't know if that greases the wheels of commerce in the way that we need to grease those wheels in order to have an effective society.
Your Honor, it's a very good question and a good point, of course. The primary distinction here is that what was sent by appellee 2 hours later was not what had been discussed or agreed. And that is a change. And there were also provisions that, as I said, there was a discussion that there should be a full agreement done at that point in time, not just a memorial from the mediation, which then eventually goes into something else, and in fact, that never did happen. But the problem here, Your Honor, the other problem that is not up at the surface is that essentially this is a case that should have never gotten this far, and the reason I say that is because the Kiowa clearly provides, with respect to a super lien, that the HOA cannot put the entirety of its lien in front of the first deed of trust in the mortgage holder. And that's exactly what it did in this case. This case was allowed to proceed because even though the first mortgage deed of trust was, the mortgage company was never notified, the tenant was never notified. And the terms of, that were required by, or proposed by the defendant, or the plaintiff appellee, says also that the money will come out of the proceeds of a sale, but at that point in time, and this was one of the concerns that was raised, the proceeds of a sale, the most likely market value out of this property, was not going to be sufficient to pay the mortgage company and to pay the plaintiff. And there were no other assets to be had. And so what essentially enforcing this particular agreement more impacts in an adverse way the statute of frauds, because it has to do with a sale, not a direct sale, but a requirement of a sale, and also seeks to regulate who that sale could be to. And it essentially, in the facts and circumstances of this case, means that the HOA would get a super lien that was far in excess of the 6 months of the amounts that were owed. And I'd like to reserve the rest of my time for rebuttal.
Of course.
May it please the court, my name is Wendy Weigler, registration number 28419, and I'm here on behalf of the Atrium Condominiums Association. This case comes down, as Judge Hawthorne pointed out, to that email sent by opposing counsel and defendant Nina Kazazian on behalf of both herself and her client, NHK Investments, on May 4th, 2017. And the email, which I'm aware that the court is aware of, but I'd like to break it down a little. It says, I am now authorized to say that the revisions you proposed below are acceptable to both of the defendants, period. Please handwrite or type these changes on the document from mediation, and we will initial the changes and reaffirm the settlement. So there's a few things to unpack in that one email. Starting with, she wrote the email. So after she said it was acceptable to both of the defendants, she could have said, please draft a new agreement with all of these terms and we'll consider it. Of course, we'll have to have a final agreement. She could have said any of those things, but she is the one who asked that only the revisions be added into the document from mediation. So the document from mediation was still very much alive and contains all of the material terms of the agreement between the parties. She was the one who said, we will initial the changes. She didn't say that we'll sign a new agreement. She said, we're just going to initial the changes. Like when you write in a change to an already signed document, people initial them. So there's no question later on whether they agreed to that change. And that was her suggestion, to initial the change, not sign the entire document. And finally, and reaffirm the settlement. So reaffirm has several meanings, including to make a renewed commitment to something, to ratify and accept a voidable transaction, and to confirm the validity or correctness of something previously established. That is exactly what happened. And before this court and before the trial court, appellant has argued that you can't reaffirm a rescinded agreement. There's no authority for that, and that is, the opposite is what happened. She absolutely reaffirmed the agreement after it was rescinded.
Ms. Weigler, can I interrupt you, please?
Yes.
It seems, though, that Ms. Kazazian is saying that what you ultimately sent her in response to that email, where she said all of those things that you just mentioned, that what you ultimately sent her was different and contained more than what she said she and NHK were going to agree to in initial. How do you respond to that?
Well, it's not true. The only items changed were the items identified first in the email, which she responded to say, these revisions are acceptable. So one thing she said that was changed is that she said, I slipped in a protection for myself, and that is absolutely not true, and the record does not reflect that. Because if the court looks at the original signed agreement from mediation, you'll see that the release paragraph, which was paragraph 7, listed as it lists all the different agents, heirs, executors, comma, employees, no comma, attorneys, comma, and assigns. That was in the original document that we signed on May 2nd. Then if you look at the versions of the revised document, the same language is there. And if I had added that in, you can count on the fact that I would have put in the comma in the right place. That language was in there as typed up by the mediator in mediation. Regarding the rest of it that she says was added in and not agreed to, all of this was considered by the trial court and rejected because none of it was material. One of the items that she said was different was that instead of saying 6 months, I had added in the actual date. That was 6 months, November 2nd. And the trial court found that, so what? It's accurate. It's not a material change. And I think the only other thing was adding in nunc pro tunc, which, I mean, I don't think that that's a material difference when the original agreement was made on May 2nd and the revisions were then accepted on May 4th. I can't see how in the grand scheme of things of having to sell the property in a 6-month period would matter what the nunc pro tunc date was. So a settlement agreement is a contract to end judicial proceedings, and accordingly, for it to be binding and enforceable, there must be a meeting of the minds as to its terms and conditions. We know in this case that there was a meeting of minds as to all the terms and conditions because we had the original mediation agreement, which included, and then the subsequent versions of the settlement agreement all included the provision, paragraph 8, that said the parties shall reduce this agreement to a more formal settlement agreement within 14 days. However, in the absence of such further documentation, the parties specifically intend for this agreement to be specifically enforceable. So for both sides to have agreed to this mediation settlement agreement and further agreed that if there was no further agreement, this would be enforceable, we know that that was a meeting of the minds and that agreement contains all of the material terms. And as the law holds, the mere intention to reduce an oral or informal agreement to writing or to a more formal writing is not of itself sufficient to show that the parties intended that until such formal writing was executed, the informal contract should be without binding force. With regard to the standard of review on issue number 2, which was the existence of a contract, we disagreed as to the standard of review, and our position is that the correct standard of review is because when the existence of a contract is at issue, the fact finder decides whether a contract in fact exists, and then appellate courts are bound by the factual findings when competent evidence exists in the record. Therefore, unless those findings are clearly erroneous, they will not be reversed on appeal. I believe the appellant had put in the brief that the standard was de novo. Getting to the issue of the sufficiency of the evidence and issue 3, the whole offer of proof fiasco. And Judge Bernard pointed out correctly that evidence was admitted. Appellant keeps representing over and over that there was no evidence, and that is just simply not what the record reflects. The record reflects that the court admitted the association's exhibits A through H, both after hearing the foundation and the objections, overruling the objections, and also finding that the exhibits were self-authenticating. Although my initial presentation, being in this tricky position of the only possible witnesses really to these emails were myself and Ms. Kazazian. So it seemed to me that an offer of proof, which maybe it shouldn't have been called an offer of proof, but basically a narrative presentation would work best in that situation. But the bottom line is that I was ultimately sworn in as a witness and examined by Ms. Kazazian. And as the trial court said, call it direct examination, call it cross-examination, call it an elephant. I don't care. She's on the stand. Ask her the questions. And that's what happened. She was sworn in as a witness. She testified. Appellant's exhibits were admitted into evidence. There was evidence. So it is completely a misrepresentation of the record to say that there was no evidence at this hearing. Finally, the first issue raised in the appellant's brief is that there was required to be a signed written agreement under the Dispute Resolution Act. And that argument is completely contrary to the Supreme Court's holding in the Yackel case and subsequent cases. And that is for these reasons, the trial court found that the appellant's actions in opposing this settlement agreement were frivolous and groundless and awarded a portion of attorney's fees to the association. That's being appealed separately, so it's not before the court. The statute of frauds, that's a non-issue. Clearly, the settlement agreement is not an agreement for the sale of property. It's an agreement for what the parties were going to do to resolve this case and what would happen if they didn't do those things. There would obviously be a contract if there was a sale of the property, and that would satisfy the statute of frauds. So the association, the appellee in this matter, requests that the court affirm the decision of the trial court and consider awarding the association its attorney's fees for the same reason they were awarded in the court below. And that will conclude my presentation unless there's any other questions.
Thank you, Counsel.
Thank you.
Ms. Kazazian, you have a minute and a half.
Thank you. A couple of points I wanted to respond to on rebuttal. First of all, the circumstances of the mediation. This mediation agreement was signed at 7:30 p.m. and was only signed because the plaintiff appellee offered to put in a rescission provision. So, and one of the reasons it was rescinded was because Now, technically speaking, maybe Ms. Weigler didn't sit down at the computer and type, but she did, I remember hearing under her, secretly say to the mediator, and attorneys, you have to add in and attorneys.
Is that part of the record, Ms. Kazazian?
Yes, it is. I believe it is part of the testimony that I presented at the hearing, which would be in the supplemental record, part 4 of the May 25th, 2017 transcript, pages, I think it was 133 to 150.
That's okay. That's
Okay.
okay. We'll-
Sorry. The position that we're taking here is that it's not that there wasn't any evidence. It's that the evidence that was admitted, that was properly admitted, does not support the findings of the trial court. The offer of proof is not a way to lay a foundation to put in evidence, and discerning or inferring what an email says or doesn't say when there was an opportunity to ask those questions, but they were not asked by opposing counsel. I don't think that it's fair to assume, especially when that's not in the record. And I see that I am out of time. So with respect to the award of attorney's fees, we ask that the court deny that request, because if the appellees are seeking to enforce the agreement that they wrote does not provide for an award of attorney's fees.
Thank you, counsel, for your arguments today. The case will stand submitted, and an opinion will issue in due course. This concludes our docket for this afternoon, and the bailiff may so announce. Thanks for coming.